Welcome to the Deep Dive. Today, we're heading into a really fascinating story. It involves dust, serious disease, and ultimately, a landmark case in the High Court of Australia.
It sounds almost mundane at first, dust. But this case, Dasreef v. Hawchar, it really shook things up in terms of evidence law.
Exactly. It's not just some dry legal argument. It's about a worker, a Mr. Hawchar, fighting for justice after getting sick from simply doing his job, cutting stone.
A job that exposed him to dangerous silica dust.
Right. And the core of the battle became this huge challenge. How do you actually prove, years down the track, how much of this invisible, dangerous dust he was breathing in day after day?
Especially when, precise measurements weren't always taken back then. It's a real problem in these kinds of industrial disease cases. You're trying to reconstruct the past.
So this fight for accountability took Mr. Hawchar on this incredible legal journey. Started in a specialist court, the Dust Diseases Tribunal of New South Wales.
Which is set up specifically for these complex cases.
Then it went up to the NSW Court of Appeal when the employer, Dasreef, wasn't happy with the result.
And didn't stop there.
No, it went all the way. The final stop was the High Court of Australia, the highest court in the land.
And that's where this case really made its mark. Because it wasn't just about Mr. Hawchar anymore, as tragic as his situation was. It forced the High Court to clarify some fundamental rules.
Like what?
Well, two big things, really. First, how courts should handle expert evidence. When can a scientist or an engineer give their opinion, and what do they need to show the court?
Okay, the rules for the experts.
And second, something perhaps even more surprising, how much can judges, especially those in these specialist courts who see similar cases all the time, rely on their own experience and knowledge when deciding a case? Can they just say, look, I've seen this before, I know how this works?
That's a really interesting question. Can the judge become almost like an expert themselves?
Precisely. And this case drew a very clear line on that.
So today, using the court documents, the judgments, the case summaries we've got, we're going to unpack this whole saga. We'll look at the key people involved.
The human story behind the legal arguments.
Follow the twists and turns through the courts.
Including some really intense legal debates.
And really get to grips with how Dasreef v. Hawchar fundamentally changed the rules of the game for expert evidence and judicial experience right across Australia. It had a massive impact.
It really did. Let's dive in.
Okay, so to really understand what happened, we need to know who the main players were. Let's start with the person at the absolute center of it all, Mr. Hawchar.
Yes, the claimant. The sources tell us he was diagnosed with scleroderma, which is a nasty autoimmune disease, back in late 2004.
And then, crucially for this case, early-stage silicosis in May 2006.
Silicosis being that lung disease caused specifically by inhaling silica dust.
He worked for Dasreef Pty Ltd, cutting sandstone, from October 1999 until May 2005, so about 5.5 years.
And his whole case was built on the claim that during that time, Dasreef basically failed him. They breached their duties, statutory duties, duty of care in negligence, even breach of contract by exposing him to unsafe levels of silica dust.
And he described the work himself, didn't he? Using power tools on stone.
Yeah, generating, as he put it, large quantities of airborne dust. He said he wore a mask, but felt it just wasn't enough. The dust got through anyway.
So the big legal fight became about proving just how much dust that was, quantifying the exposure level.
Exactly. Which brings us to the defendant, Dasreef Pty Ltd, his former employer.
Their position was pretty straightforward, I suppose. They disputed his claims.
They did. They argued about the actual level of dust exposure, saying it wasn't as bad as he claimed. But perhaps more importantly, they launched a major challenge against the evidence Mr. Hawchar used to try and prove those levels. They questioned whether that evidence was even admissible in court.
Which leads us nicely to a really key and ultimately quite controversial figure, Dr. Kenneth Basden.
Ah, yes, Dr. Basden. The expert witness called by Mr. Hawchar's team, highly qualified on paper, chartered chemist, chartered professional engineer, retired academic from UNSW.
Sounds impressive. So what was the controversy?
It was about the nature of his opinion evidence. He gave an opinion on the likely concentration of silica dust Mr. Hawchar would have been breathing.
And what did he say?
This is the really striking part. He estimated the dust levels would be of the order of 1,000 or more times the legal exposure limit.
1,000 times. Wow.
He even suggested it could be approaching 1 gram per cubic meter, which is, an incredibly high level. It paints a picture of extremely hazardous conditions.
So why was that controversial? Surely that helps Mr. Hawchar's case Immensely.
It would if it was admissible. The problem, and this became the absolute crux of the appeal, was how he arrived at that 1,000 times figure. It wasn't based on actual air monitoring tests done at Dasreef while Mr. Hawchar was working there. It was essentially an estimate based on Dr. Basden's general experience, his observations of the type of work, and maybe comparisons to other situations.
So it was more of a subjective judgment, a ballpark figure.
Kind of. And the legal question became, does Dr. Basden's specific expertise actually allow him to make that kind of quantitative leap, to put a specific, very high number on it without direct measurements in this specific workplace? And could that number then be used reliably in calculations, say, to work out an average exposure? That's what Dasreef challenged.
Got it. So the fight wasn't just about the dust, but about the expert's methodology and whether it met the legal standard.
Exactly, the admissibility hurdle.
Okay, who else was key? There was another expert, wasn't there? Professor Henderson?
Yes, Professor Henderson, a pathologist. He also gave evidence for Mr. Hawchar, but his evidence was quite different, and crucially, it was uncontested. Dasreef didn't dispute what he said.
And what was his key contribution?
Two things. First, the fundamental medical fact. Silicosis is only caused by exposure to silica dust. There's no other cause. That immediately links the diagnosed disease to the type of dust Mr. Hawchar was exposed to at work.
Right, that establishes the causal agent.
Second, Professor Henderson gave an opinion based on the latency period of Mr. Hawchar's silicosis, the time it took for the disease to develop after exposure. He said the relatively short time frame suggested the exposure must have been intense.
Intense.
And that this intense exposure was very likely attributable to the period Mr. Hawchar worked at Dasreef, those 6 or so years. This provided a strong causal link based purely on the medical evidence, separate from Dr. Basden's disputed numbers.
Okay, that sounds like pretty powerful, undisputed evidence. Now, I'll talk about the judges involved. The first one was Curtis J. at the Dust Diseases Tribunal.
Yes, the primary judge. He heard the whole case, first listened to Mr. Hawchar, the lay witnesses. Dr. Basden, Professor Henderson saw the objections from Dasreef. He ultimately found in Mr. Hawchar's favor on the silicosis claim.
But his handling of the case raised some eyebrows, didn't it? Two main things, according to the sources.
That's right. First, the procedure. Dasreef raised all these objections to Dr. Basden's quantitative evidence during the trial. They even had a whole separate hearing of voir dire about it. But Curtis J. didn't rule on those objections then and there.
He just deferred the decision.
Yes. He said he'd deal with the admissibility question in his final judgment. The High Court later called this unsatisfactory. It leaves everyone hanging during the trial.
I can see why. And the second thing?
This was about his reasoning for finding causation. In his written judgment, he explicitly said he was relying not just on the evidence presented in this case, but also on his own general experience as a specialist tribunal judge.
What does he mean by that?
He basically said, look, I sit in this tribunal, I see lots of silicosis cases, and my experience is that this disease is usually caused by very high levels of silica exposure. So he was drawing on his background knowledge from other cases to help decide this case.
And Dasreef obviously didn't like that either.
Not at all. That became another major ground for appeal.
So Dasreef appeals. The case goes to the NSW Court of Appeal. Who heard it there?
The bench was President Alsop, Justice Basden, and Justice Campbell. They had to review Curtis J.'s decisions, particularly the admission of Dr. Basden's number and the reliance on judicial experience. And there was also a separate fight about the costs awarded.
And what did the Court of Appeal decide?
It was a bit of a mixed bag for Dasreef. They actually won on the costs issue. The Court of Appeal agreed the primary judge made errors in calculating costs and sent that part back to the tribunal to be redone.
Okay, so a partial win.
But crucially, they lost on the main point. The Court of Appeal upheld the finding that Dasreef was liable for causing Mr. Hawchar's silicosis.
Even though they seemed to agree there were problems with Dr. Basden's evidence and the judge's use of experience.
Yes, their reasoning was interesting. They essentially said, even if you disregard Dr. Basden's contested number, and even if the judge shouldn't have relied on his general experience, there was still enough other perfectly good evidence, Professor Henderson's uncontested testimony about silicosis only coming from silica dust, and the latency period pointing to intense exposure at Dasreef to justify the finding of liability. The conclusion was right, even if some of the steps taken to get there were flawed.
So the core finding stood.
It did. Although, importantly, the Court of Appeal did agree with Dasreef that the primary judge shouldn't have relied on his general experience. They used the opportunity to clarify that point of law for the DDT.
Right. So Dasreef still facing liability, decided to go for the final option, appealed to the High Court of Australia.
The ultimate legal authority. The sources lived the full bench, Chief Justice French and Justices Gummow, Hayne, Crennan, Kiefel, Bell, and Hayden. A very heavyweight panel to consider these issues.
And we should mention the lawyers arguing before them. For Dasreef, trying to overturn the liability finding, was Mr. Jackson.
He had the task of convincing the High Court that the errors made by the primary judge admitting Basden's number, using personal experience, were so significant that the whole liability finding should fall.
And defending the outcome for Mr. Hawchar was Mr. Toomey.
His job was to argue that the Court of Appeal got it right, that even with those potential errors, the liability finding was soundly based on the other evidence, particularly Professor Henderson's. The sources show him grappling with the arguments against Dr. Basden's evidence during the High Court hearing, trying to argue it should go to weight, not admissibility. And of course, solicitors for both sides were working tirelessly behind the scenes throughout all these appeal stages, preparing submissions, instructing counsel.
Okay, one last group to mention before we trace the journey. The lay witnesses. These weren't experts, just people who saw what was going on.
Right. There was Mr. Yusuf, a co-worker of Mr. Hawchar, who gave evidence about the general conditions.
And perhaps more vividly, Mr. Buono, the owner of the factory next door to Dasreef.
His description, as recorded in the sources, is really quite stark. He talked about dense clouds of highly visible fugitive dust coming from Dasreef's yard. Not just occasionally, but for hours at a time, 3 or 4 times a week.
Wow. He said it coated cars in his yard.
Coated cars affected his staff, even his wife who had asthma and worked in their office nearby. It paints a powerful picture of the environment, completely separate from the complex expert debate about milligrams per cubic meter. Just what people could see with their own eyes.
So that's the cast. The worker fighting for his health, the employer defending its practices, the experts offering different kinds of evidence, the judges grappling with procedure and substance, the lawyers arguing the points, and people who just saw the dust.
A complex human and legal drama.
Definitely. Okay, let's walk through how this actually unfolded in the courts. What was the sequence of events?
Well, as we said, the timeline really starts before court, with Mr. Hawchar's employment from late 1999 to mid-2005. That's the crucial exposure period.
And during that time, the legal standard for silica dust exposure was BO.2 milligrams per cubic meter, averaged over a week. That's the benchmark Dasreef was supposed to meet.
Correct. Then, in mid-2004, Mr. Hawchar starts getting sick, joint pain, finger swelling. By late 2004, he's diagnosed with scleroderma,
which forces him to stop working in May 2005.
And then a year later, May 2006, comes the silicosis diagnosis.
Now, the sources mention he also did some private stonemasonry work on the side and maybe had exposure before working at Dasreef. How did the court handle that?
That's important, yes. The trial judge, Curtis J., had to consider all potential sources of exposure. He heard evidence about Mr. Hawchar's work history, including some time in Lebanon before Dasreef, and the private work he did between 2002 and 2005.
And he made an apportionment.
He did. He essentially divided up the responsibility for the total dust exposure. He attributed 1 part to the pre-Dasreef period in Lebanon, 2 parts to the private work, but the vast majority, 20 parts, or 87%, he attributed directly to the employment at Dasreef.
So while acknowledging other exposures, the judge found Dasreef was overwhelmingly responsible for the dose that caused the silicosis.
That was his finding, yes, based on the evidence of the duration and likely intensity of exposure during each period.
Okay, so with the diagnosis clear and the main source identified, Mr. Hawchar formally starts his legal claim in October 2007, files it in the Dust Diseases Tribunal.
His solicitors would have prepared the statement of claim, setting out the allegations: breach of statutory duty, negligence, breach of contract. Dasreef's solicitors would then file a defense.
And then something interesting happened before the trial even started. Dasreef made a settlement offer.
Yes, in October 2008, a formal offer of compromise under the rules. They offered $500,000 plus costs and covering the workers' compensation payments already made.
But Mr. Hawchar rejected it.
He did. And the Court of Appeal later said that was perfectly understandable. Accepting settlement offers, especially when ongoing workers' compensation is involved, can be really tricky. You have to be careful not to jeopardize future entitlements. There would have been detailed correspondence back and forth between the solicitors for both sides about this offer.
Right. So no settlement. So trial begins on October 27th, 2008, before Curtis J.
Mr. Hawchar presents his case first. His own story, the evidence from his coworker, Mr. Yusuf, and the powerful description from the neighbor, Mr. Buono, about those dust clouds.
Then the expert evidence. Professor Henderson on the nature of silicosis and the latency period pointing to intense exposure at Dasreef.
Which was uncontested.
And Dr. Basden, with his striking opinion about exposure being potentially 1,000 times the limit.
That's when the defense, Dasreef, really pushed back. Over 70 objections were apparently lodged against the plaintiff's expert evidence. A specific hearing of voir dire was held just to argue about the admissibility of Dr. Basden's evidence.
But this is where Curtis J. made that procedural decision we talked about. He didn't rule on admissibility then, he deferred it.
Yep, left it hanging until the final judgment, a move later criticized by the High Court as generally unsatisfactory.
So the trial concludes, and Curtis J. delivers his judgment. Fines for Mr. Hawchar on silicosis, awards him just over $131,000 in damages.
And in his reasons, he does two critical things that fuel the appeals. First, he explicitly uses Dr. Basden's 1,000 times estimate in a calculation.
How did he do that?
Well, he estimated Mr. Hawchar spent maybe 30-40 minutes actively cutting stone per day. He then took Dr. Basden's broad estimate and plugged it into a formula to calculate a time-weighted average TWA exposure for Mr. Hawchar. He came up with a figure between 0.25 and 0.33 milligrams per cubic meter.
Which was above the legal limit of 0.2.
Exactly. So that calculation, based on Dr. Basden's contested estimate, directly supported the finding that Dasreef breached the safety standard, even though Dr. Basden himself hadn't intended his estimate to be used quite so precisely.
Okay, that's the first thing. And the second?
The judge explicitly states he's using his experience as a specialist tribunal judge, noting that this disease is usually caused by very high levels of silica exposure to help him conclude causation, bringing in his general knowledge from outside the specific evidence of this trial. And he made costs orders too, which also got appealed.
Understandably, Dasreef appeals these points to the NSW Court of Appeal. They had an automatic right to appear on questions of law and evidence admission.
Their arguments focus squarely on those two issues. The judge wrongly admitting and using Dr. Basden's numerical opinion and wrongly relying on his own personal experience.
The Court of Appeal panel Alsop P., Basden J.A., Campbell J.A., looked closely at Dr. Basden's evidence. They noted his cross-examination revealed the number was more of an estimate drawn from experience than a rigorous calculation applicable here.
And they scrutinized the judge's reliance on experience, considering the rules in the Evidence Act.
Their judgment comes down. They allow the appeal in part. They agree the cost orders were wrong and send that back to the tribunal. The solicitors for both sides would have been heavily involved in arguing those specific costs points.
But the big one, they dismissed Dasreef's appeal against the finding of liability.
Right, this is the bit that seems tricky. They found potential errors in the reasoning, but upheld the result.
Because of the other evidence, they emphasized the uncontested facts. Mr. Hawchar had silicosis. Silicosis only comes from silica dust. Professor Henderson's evidence pointed to intense exposure during the Dasreef employment. They said this was enough on its own to prove causation, regardless of the issues with Dr. Basden's number or the judge's experience comment.
So the errors, while real, didn't actually affect the ultimate outcome on liability in their view.
Correct. They also used the judgment to firmly state that DDT judges cannot rely on general experience like Curtis J. did, overruling some potentially conflicting earlier Court of Appeal decisions.
So, Dasreef faces liability again. Their last resort is the High Court. They presumably get granted special leave to appeal. Mr. Jackson is now arguing for Dasreef, Mr. Toomey for Mr. Hawchar.
Before the 7 High Court justices, the arguments crystallize around those two core legal issues with national significance.
Issue 1. Was Dr. Basden's numerical opinion admissible under Section 79 of the Evidence Act, that key provision about expert evidence based on specialized knowledge?
And Issue 2. Can a judge in a specialist tribunal bound by the rules of evidence rely on their general accumulated experience to decide facts in a specific case?
The High Court transcript excerpts show a real deep dive into this. They're debating the meaning of wholly or substantially based on specialized knowledge in Section 79. What does actually require an expert to show?
Exactly. Is just stating your qualifications and giving a conclusion enough? Or do you have to explain your reasoning process, the link between your knowledge and the opinion? They discuss the history, the common law basis rule, cases like Makita, Law Reform Commission reports, trying to pin down the purpose of Section 79.
Mr. Jackson for Dasreef argues strongly. Dr. Basden's number wasn't properly based on his expertise for this specific calculation. He didn't show the steps.
Mr. Toomey, for Mr. Hawchar, tries to argue it goes to weight, not admissibility. He uses an analogy: a geologist identifying ore doesn't always need to detail every step. He suggests making experts spell everything out could bring back old complexities Section 79 tried to remove.
But the justices seem skeptical of that line, especially regarding admissibility. Justice Crennan's point about ipse dixit, the bare assertion, seems key. The court needs to see the basis to decide if it's admissible expert opinion at all.
Right. And on the judicial experience point, Mr. Jackson argues Curtis J. went way beyond acceptable judicial notice or any specific statutory exceptions like Section 25B of the DDT Act, which deals with relying on previously determined general issues, not just a judge's feeling. Mr. Toomey tries to link the judge's comment to Professor Henderson's evidence, but it doesn't seem to fly.
Okay, so after all this argument, the High Court delivers its unanimous judgment. All 7 justices agree on the core principles.
First, Dr. Basden's evidence in Section 79. They agree with Dasreef and the Court of Appeal. His opinion estimating the numerical level of dust used for that TWA calculation was not admissible under Section 79.
Why not?
Because his specialized knowledge, while broad, didn't extend to making that specific quantitative estimate in that specific way, i.e. without measurements or a validated methodology for this context that could then be reliably used in a calculation. It was a ballpark figure, not an opinion wholly or substantially based on his specialized knowledge for that purpose.
And crucially, they clarified what Section 79 requires for admissibility.
Yes. This is the big takeaway. It's not enough for an expert to just say, I'm an expert, here's my opinion. The reasoning process, how their specialized knowledge connects to the facts or assumptions and leads to the conclusion, must be identifiable. The court needs to see that link. The bare ipse dixit is out.
So the expert needs to show they're working, essentially.
In a way that allows the court to assess if the opinion truly flows from the expertise. This helps the judge decide admissibility and helps the judge or jury decide how much weight to give it later. It also means if the factual assumptions aren't proven, the opinion might lose its basis and be inadmissible or worthless. The party tendering the expert has to demonstrate this connection.
Okay, that's a major clarification on Section 79. What about the judge's experience?
They agreed with Dasreef and the Court of Appeal on that too. The primary judge erred by relying on his general experience from other cases to decide causation here.
So specialist judges can't do that.
Not if their tribunal is bound by the rules of evidence, like the DET is. They must decide the case based only on the evidence presented in that trial. General experience can't substitute for evidence unless it falls under narrow exceptions like judicial notice of notorious facts, Section 144, or specific statutory powers like relying on formally determined general issues, Section 25B, neither of which applied here in the way the judge used his experience.
So 2 clear errors found by the High Court. But what was the final outcome for Dasreef's appeal against liability?
Despite finding those errors, the High Court dismissed Dasreef's appeal on liability. Just like the Court of Appeal, they found that the conclusion that Dasreef caused Mr. Hawchar's silicosis was still soundly supported by the other evidence.
Professor Henderson's uncontested evidence again.
Exactly. The facts that silicosis is only caused by silica and the latency period pointed to intense exposure during the Dasreef employment were enough. The errors regarding Dr. Basden's number and the judge's experience didn't undermine the separate, sufficient basis for finding causation.
Wow. So Dasreef lost on liability at every level, despite identifying significant legal errors along the way. What about costs?
The High Court agreed with the Court of Appeal that the original cost orders were flawed and needed to be redone by the tribunal. So Dasreef had some success there, and importantly, succeeded in getting the High Court to clarify these major points of evidence law.
Which brings us neatly to the impact. How did Dasreef v. Hawchar actually change things in Australian legal practice? It sounds like the effect was pretty significant.
Oh, absolutely. It's now the leading case on Section 79 of the Uniform Evidence Acts. Anyone dealing with expert evidence needs to know Dasreef.
So the biggest impact is this refined standard for expert evidence admissibility.
Definitely. It hammered home that the opinion must be wholly or substantially based on the expert's specialized knowledge.
But the key addition was the focus on the basis and the reasoning.
Precisely. It's not just about having the right qualifications. The expert and the lawyers calling them need to make sure the reporting testimony clearly show how the expert got from their knowledge and the facts assumptions to the conclusion. That reasoning process has to be transparent.
No more, trust me, I'm an expert. The bare ipse dixit is dead.
Well, it certainly should be for admissibility under Section 79. The court needs to be able to follow the logic to ensure the opinion is actually grounded in the expertise claimed. It's a safeguard against opinions just masquerading as expertise.
Has this actually changed how lawyers and experts prepare for court?
Yes, significantly. Expert reports tend to be more detailed now in setting out the reasoning. Lawyers are much more focused on ensuring that chain of logic is clear, and courts are more willing to hold admissibility hearings, voir dires, to test whether an expert opinion meets the Dasreef standard before it even goes to the jury or judge for consideration.
So it's a higher bar, or at least a clearer one, for getting expert evidence admitted.
It clarifies the requirements. It also reinforces the idea that if the factual basis the expert relies on isn't actually proven by other evidence, the opinion might fail anyway, either because it lacks relevance or because the necessary link between knowledge, facts, and opinion isn't established.
Okay, that's the expert evidence part. What about the impact on judges using their own experience?
That was the second major clarification. Dasreef put clear limits on that, especially for specialist tribunals bound by evidence rules. Judges can't just import knowledge from past cases to decide contested facts like causation in the current case.
Their decision has to be based purely on the evidence presented in this trial.
Overwhelmingly, yes. Unless it fits into those narrow legal exceptions, like judicial notice of truly obvious facts, or specific statutory powers allowing reference to findings from other cases, like the DDT's Section 25B, which wasn't properly used here. It reinforced the principle that justice must be seen to be done based on the evidence argued between the parties in open court.
And the High Court's comment about deferring admissibility rulings, did that have much impact?
It served as a strong reminder of best practice. While judges still have discretion, the preference is clear. Decide significant evidence objections, especially about experts, early on. It provides certainty for the parties about what case they need to meet.
So, reflecting on the whole journey from that dusty workshop where Mr. Hawchar worked, all the way to the High Court, it's quite a story.
It really is. A single worker's tragic illness led to the highest court clarifying fundamental principles of how truth is established in our legal system.
And the key takeaways are clear. Expert opinions need that demonstrable basis, that clear reasoning tied to knowledge. And judges need to stick to the evidence presented in the case before them.
Yet, despite the legal errors made along the way concerning some of the evidence and reasoning used, the ultimate finding stood. Mr. Hawchar's claim for damages for his silicosis caused by his work was upheld.
Because of that other unshakable evidence.
Exactly. Professor Henderson's uncontested evidence provided that solid foundation.
So, for anyone listening, why does this case matter today?
Well, expert evidence is everywhere, isn't it? Workplace injuries, medical cases, complex financial disputes, even criminal trials rely heavily on experts. Dasreef v. Hawchar means that anyone presenting or challenging expert evidence now has to look much more closely at the how and the why behind the opinion, not just the final conclusion. It's about ensuring the evidence is genuinely expert.
It's a safeguard, really.
It is.
And it leaves us with a fascinating thought, doesn't it? This underlying tension the case exposed.
Between wanting judges in specialist areas who build up so much valuable knowledge to use that knowledge.
And the fundamental principle that court decisions must be based only on the evidence presented and tested in that specific case to ensure fairness to everyone involved.
How do you balance harnessing that deep experience without compromising the rules of evidence and impartiality? It's a challenge courts constantly face, especially as the world gets more complex and specialized.
A really critical balancing act.
Indeed. The legacy of Mr. Hawchar's fight against the dust continues to shape how justice is done.
Thanks for joining us for this deep dive into Dasreef v. Hawchar. We hope walking through the story and the legal reasoning has shed some light on its importance.